I come from a small community in Illinois called Kankakee, about 40 miles south of Chicago.
I'm Rob Johnson. I'm district attorney from Alamance County. There's several district attorneys here today.
Capital punishment, to me, was something that was there, it was in the abstract, it was out there, I knew about it, and didn't pay much attention to it.
We are here to express our opposition to this bill.
When I did think about capital punishment, it was because of a very notorious crime, and I wanted the police to find them, to convict them, to lock them up, throw away the key. And if it was bad enough, I wanted them to get the chair. We thought that was all the better.
It is certainly something the public wants. By and large, the public wants a death penalty, and I think that we as legislators should ensure that they have one if, in fact, that's the consensus of the North Carolina public.
But unfortunately, at least in Illinois, that system doesn't always get it right.
The question that I think we need to ask ourselves is the system broken or is the system working?
The death penalty should be reserved for those very extremely heinous crimes, murder against law enforcement or murder against a prison guard or a murder, rape. There's many circumstances in which the death penalty applies.
We're picking certain people out, not quite at random, but not certainly systematically either. It's not always the worst cases that get death. Very often what will happen is there'll be 3 people involved in a homicide, and those that are the quickest to make a deal with the prosecutor to turn state's evidence, to give testimony, will come up with a 20-year sentence or a 10-year sentence, even if they're the most responsible for the death. And the defendant who's left last to speak to the prosecutor is the one who goes to death row.
What may be a capital offense in one county wouldn't be a capital offense in another, simply because the prosecutor doesn't choose to prosecute it that way, no matter if the crimes are the same.
So it's become clear, I think, to those of us who've studied this system that other things are operating in the courtroom with regard to this life or death, very subjective decision.
Nobody believes that guilty people should go unpunished. It just doesn't seem to us that you should have a penalty that's almost whimsically applied.
Of course we feel moral outrage at the death of innocent people. Who does not feel moral outrage over the death of innocent people? And we need to feel it. Now, it is interesting in our society. We sure seem to feel more outrage over the death of some people than over the death of other people.
Using Dr. David Baldus's research, Professor Jack Boger argued a landmark case before the U.S. Supreme Court in 1987, which challenged the constitutionality of a racially discriminatory death penalty system. Baldus found that race played a significant role in death penalty sentencing in Georgia, but not in all cases. When a murder involved especially high or low levels of aggravating circumstances, the outcome was more straightforward, and race didn't play a significant role.
But in cases that were moderately aggravated, where a person who supported the death penalty could say, yeah, I could see that this might be a capital case, but maybe not, depending on the mitigating factors. In those cases, race played an important role. So that if you had 2 defendants, one of whom had a prior capital felony, and the other of whom had killed a white victim, they were equally likely to receive a death sentence for those factors alone.
These findings were corroborated in a more recent study of North Carolina homicide cases from 1993 through 97.
What we found was unmistakable evidence that race continues to play a part in capital sentencing in North Carolina. Very much as Professor Baldus found that racial discrimination enters in based upon the race of the homicide victim. If the victim is white, the odds are significantly higher, 3 to 4 times as high, that a death sentence will be imposed as if the victim is not white.
It is not that they get up every morning and say, I'm going to go discriminate against an Indian or a black. It's just a subconscious way that society works. And we're all guilty of that. We're all guilty of it. And the death penalty is no different.
And so when a white doctor is killed, when a white sales clerk is shot at a 7-Eleven, the community response and the prosecutor's response says, I'm not going to deal down to a lesser offense. I'm going to stay here on the weekend and gather the evidence and put this case before a jury and demand a death sentence. When the defendant is black and the victim is black, on the other hand, there's this sense, oh well, it's the killing among black folk, and we certainly don't approve of it, but we're not going to work especially hard to make this the case that we hold up as the symbol of our anger.
Prosecutors are aware that overall whites support the death penalty more than minorities.
And there, I think the prosecutors are more self-conscious, sometimes racially, than jurors themselves, selecting juries that they think will be more likely to return the verdicts they want.
Don't isolate that, because race over the years has been a factor in the issuing of traffic tickets. It's been an issue in who gets served in restaurants first. So it's a little microcosm of society, and that's all it is.
Interestingly, when we got to the Federal Court of Appeals, one of the judges actually said during the oral argument, Mr. Boger, we know there's racial discrimination in the death penalty, but what do you expect us to do about it? What can be done about something like that? The truth is, it's racial discrimination. You've got to eliminate it. So that's what we brought. Justice Powell rejected it and said, in effect, this is an attack not simply on Georgia's death sentencing system, it's an attack on the criminal justice system as well, because if it's true about the death penalty, it may be true about other lesser crimes. Now, the dissenters, Justice Brennan, said, that's a remarkable statement. If there's race discrimination more broadly in the criminal justice system, there are two things one can do. One can either sweep it under the rug and say we're not going to think about it, or one can actually begin to address those disparities as well. The death penalty is not just a symbolic statement about our anger about crime, because I share that anger about violent crime. It is literally taking certain lives and extinguishing them in order to express that social outrage. If a white person is killed, send them to death. If a black person is killed, well, it's too bad. Give them a life sentence, give them 20 years, and let's go on about our business. I think we need to look closely to see whether that's what we're doing, because if it is, it's only a step or two less heinous than executing the innocent. If it's true that the only way you can have capital punishment is to have racially discriminatory capital punishment, then I think society owes itself a serious discussion about whether it ought to carry out the death penalty under those circumstances.
But nobody who's in favor of the death penalty wants to execute someone who's innocent.
Now, I can understand maybe making a mistake once, maybe even twice, but 13 times, that's something wrong. Some were saved not by judicial review, but by 20-year-old journalism students. 4 men were convicted of murdering a man and a woman in a poor south suburban Chicago community called Ford Heights for a 1978 double murder. A fellow by the name of Vernil Jimerson and Dennis Williams were sentenced to death. And the primary testimony came from a 17-year-old woman who was their alleged accomplice. Questions were raised about her mental competency. She changed her story twice. And because of her cooperation, she received a 50-year sentence in prison. So just on those facts alone, I have to ask you, where's the justice? I didn't see it there. Northwestern journalism students helped poke holes in the case against the Ford Heights Ford. They found leads were provided to investigators in the days after the murders that implicated the real killers. But instead, they relied on the false testimony of a mentally challenged 17-year-old.